Welcome to this session on how to deal with grievances. The session objectives include resolving grievances informally, then we'll look at the purposes of grievances, the general principles, the procedure for resolving grievances formally, and then we'll look at some hints and tips. In organisations where managers have an open policy for communication and consultation, problems and concerns are often raised and settled as a matter of course, and this is how we resolve grievances informally. Colleagues should aim to settle most grievances informally with their line manager. Many problems can be raised and settled during the course of everyday working relationships. In the first instance, the company would suggest that you raise and try to resolve any concerns, problems, or complaints you may have relating to your employment with the company informally and orally with your line manager. Or if the problem relates to your line manager, you would need to contact his or her line manager or another senior manager of the company. You should make it clear that you are not raising a formal grievance and that you merely wish to discuss the issue informally. This informal process will not constitute part of the formal grievance procedure, although the company may retain records of any such informal discussions. There may be circumstances in which the company is obliged to instigate a formal investigation as a result of issues brought to the attention of the manager of the company on an informal basis. So, for example, allegations relating to serious acts of harassment, acts or threats of violence within the workplace, or allegations of corporate or financial wrongdoing on behalf of the company and/or health and safety issues will need to be investigated. Where a grievance is serious or a colleague has attempted to raise a problem informally without success, the colleague should raise it formally with management in writing. When stating their grievance, colleagues should be encouraged to stick to the facts and avoid language which may be considered insulting or abusive. Where the grievance is against the line manager, the colleague may approach another manager or raise the issue with the HR department. The purpose of QB having a grievance policy and procedure is to ensure that a colleague has an opportunity to raise formally with management any grievances relating to the job or complaints regarding the company or any member of the company. The grievance procedure is designed to ensure that any concerns, problems or complaints or other grievances you may have about your employment with the company are dealt with fairly, consistently and without unreasonable delay. Quintessential's brand is committed to resolving genuine disputes. However, it should be noted that investigating a grievance takes up a large amount of management time and can cause a disruption within the workplace. As a result, Quintessential brands will take any abuse of the grievance policy very seriously. If a grievance is proven to be unfounded, if it's malicious and/or spurious, and is considered that the colleague raising the grievance has acted in bad faith, Quintessential brands will consider whether disciplinary action is appropriate. This policy doesn't form part of the contract of employment, and you will not have any claim for breach of contract if the company deviates from the procedures set out in the grievance policy in any case or more generally. Let's look at the general principles. It's essential to the proper working of this procedure that any colleague raising a grievance should continue to work normally whilst the procedure is being followed. At each stage of the procedure, a fellow colleague, staff forum representative or certified trade union official may accompany the colleague raising the grievance. If the grievance relates to a disciplinary decision, the company's disciplinary appeals procedure should be used. Where a complaint or grievance relates to a particular supervisor or manager, the grievance procedure should be commenced at the stage above that in which that team leader or manager would be involved. This policy applies to employees of GJD all of QB operations and DLD, whether full-time, part-time, permanent, fixed term or temporary. It does not apply to agency workers or self-employed contractors and should not be used to complain if you've been dismissed or are the subject of other disciplinary action. If you are dissatisfied with any disciplinary action, you should submit an appeal under the disciplinary procedure. Anybody working in an organisation may at some time have problems or concerns about their work, working conditions, or relationships with colleagues that they wish to talk about with management. They want the grievance to be addressed and, if possible, resolved. It's also clearly in management's interest to resolve problems before they can develop into major difficulties for all concerned. Issues that may cause grievances include terms and conditions of employment, health and safety issues, work relations, bullying and harassment, new working practices, the working environment, organisational change, and discrimination, and grievances may occur at all levels. So the purpose of the grievance procedure and policy is to ensure that a colleague has an opportunity to raise formally with management any grievances relating to the job or complaint relating or regarding the company or any member of the company. The company's aim is to ensure that the appropriate level of the company's management deal with the grievance or complaint promptly and fairly. The procedure does not confer any contractual right. Colleagues might raise issues about matters not entirely within the control of the organisation, such as client or customer relationships, for instance where a colleague is working on another employer's site. These should be treated in the same way as grievances within the organisation, with the employer and/or the manager investigating as far as possible and taking action if required. The organisation should make it very clear to any third party that grievances are taken seriously and action will be taken to protect their colleagues. If it isn't possible to resolve your grievance informally, you may invoke the formal grievance procedure, which is as follows. Stage 1. To raise a formal grievance in the first instance, it should be raised in writing with HR and the immediate line manager. Where a matter affects a group of colleagues, a spokesperson from amongst the group should raise the matter with the immediate line manager. You must provide HR and your line manager, or if the problem relates to your line manager, to his or her line manager or another senior manager of the company, with written details of your grievance and the basis for it. This written statement should contain sufficient details to allow the relevant manager to be able to understand properly the nature of your grievance, including, for example, dates of any incidents, names of individuals involved, and any other relevant facts. The line manager will normally respond within 2 working days. The next stage is the investigation. The company will conduct an investigation to the extent necessary into your grievance. Investigations may be carried out by your line manager, or where this is not appropriate, someone else may be appointed by the company. You are required to cooperate fully and promptly with any investigation which could involve disclosing the names of any relevant witnesses, providing any relevant documents, and attending any investigative interviews that the company considers necessary. The next stage is the grievance meeting. Following such investigation as may be necessary, the company will write to you to invite you to a meeting to discuss the grievance without unreasonable delay. You will normally be provided with at least 2 working days prior notice of the grievance meeting, unless you agree to attend a meeting on shorter notice. The letter will remind you of your right to be accompanied to the grievance meeting. The meeting will normally either be held by your line manager, or if the problem relates to your line manager, his or her manager or another senior manager of the company. The company reserves the right to appoint such managers as it considers fit to hear your grievance. The company will also normally ask another suitable member of staff to attend the meeting to take minutes of the meeting and if appropriate to provide advice concerning the relevant grievance procedure. The relevant manager, you and your companion, must make every effort to take all reasonable steps to attend the grievance meeting and any follow-up meetings. The meeting will be conducted in a manner that allows both you and the appointed manager to explain their views and to make representatives and observations in relation to the grievance. In particular, you will be allowed to explain your grievance and say how you think it should be resolved. Depending upon the nature of the grievance, it may be necessary for the manager to adjourn the grievance meeting to investigate the matter further. Where the manager dealing with the grievance obtained written statements from relevant witnesses, it is the normal practice of the company to provide copies of these statements to you and to the person, if any, about whom the grievance is being raised by you. However, in particularly sensitive cases, this may not always be fair on the person who gave the statement, and the company reserves the right to withhold or anonymise any statements or other documents for this or any similar reason. You should note that all statements drafted for this purpose may be used in any disciplinary procedure and/or legal proceedings that arise from the grievance. The manager appointed by the company to consider your grievance will write to you without unreasonable delay and normally within 10 working days of the grievance hearing, unless otherwise stated. Reasons for this delay could be due to the complexity or the scale of the grievance, and they will provide you with his or her decision in relation to the grievance. They'll set out the action that the company has taken or intends to take to resolve the grievance and to notify you that you have the right to appeal if you are not content with the decision or the action taken by the company. Stage 2 concerns the appeal. If the matter is not resolved at Stage 1 or within 2 working days, the colleague raising the grievance or the spokesperson of a group may refer it in writing within 3 working days to a departmental manager or nominated deputy. The colleague raising the grievance or the spokesperson should set out the grounds for the complaint and the reason for dissatisfaction with the Stage 1 response. A meeting will normally take place to consider the matter within 10 working days of the request being made. If you are not satisfied with the decision made by the manager appointed to consider your grievance or the action taken by the company, you may appeal. In order to appeal, you must notify the company in writing of your wish to appeal without unreasonable delay, which would normally be within 10 working days of the date that the decision was communicated to you in writing, and you must set out in your letter full details of your grounds of appeal. The appeal will be dealt with impartially and wherever possible by a manager of the company's choice who has not previously been involved in the case and who is more senior than the manager who determined the outcome of the original grievance. The company will also ask another suitable member of staff to attend the appeal meeting, to take minutes of the meeting, and if appropriate to provide advice with regards to the relevant appeals procedure. As this member of staff will have no part in any decision in relation to your appeal, the company reserves the right to send the same member of staff to the appeal hearing as was present at the initial grievance hearing. The appointed manager will write to you to invite you to an appeal meeting to discuss your grounds of appeal, which should take place without unreasonable delay. You will normally be provided with at least 2 working days prior notice of the appeal meeting, unless you agree to attend a meeting on shorter notice. The manager's letter will remind you of your right to be accompanied at the appeal meeting. The manager, you, and your companion must make every effort and take all reasonable steps to attend the appeal meeting and any other follow-up meetings. The appeal meeting will be conducted in a manner that allows both you and the appointed manager to explain their views and to make representations and observations in relation to the appeal. In particular, you will be allowed to explain your grounds of appeal and say how you think your grievance should be resolved. It may be necessary for the appointed manager to adjourn the appeal meeting to investigate the matter further and to then reconvene the hearing if necessary to discuss the result of the further investigation. The appointed manager will notify you in writing of his or her decision in relation to the appeal and any action the company has taken or intends to take to resolve the grievance without unreasonable delay and wherever reasonably practicable within 10 working days of the appeal hearing. The decision of the appointed manager with regard to the appeal will be final and you will have no further right of appeal. Tips for preparing for and conducting the meeting. It's worth pointing out that throughout all of the stages of the procedure, a neutral stance should be adopted by all parties. Day-to-day departmental working practices should also continue as usual whilst any grievance is under consideration. And you should be aware that some colleagues may have difficulty expressing themselves because of language or other difficulties, and so they may like to seek help from trade union or other employee representatives or from other colleagues. Another tip is to consider the records we keep. The foreword to the ACAS Code of Practice advises employers to keep a written record of any grievance cases they deal with. Records should include the nature of the grievance, what was decided and the actions taken, the reason for the actions, whether an appeal was lodged, the outcome of the appeal, and any subsequent developments. Records should be treated as confidential and be kept no longer than necessary in accordance with the Data Protection Act and GDPR. These acts give individuals the right to request and have access to certain personal data. The Information Commissioner has produced codes of practice covering recruitment and selection, employment records, monitoring at work, and information about the employee's health. Copies of meeting records should be given to the employee, including copies of any formal minutes that may have been taken. In certain circumstances, for example, to protect a witness, the employer might withhold some information. Records will be kept by the company detailing the nature of any grievance, whether it's formal or informal, a copy of the written grievance, a copy of the appointed manager's decision, the action taken to resolve the grievance, if any, the reason for the action taken, whether there was an appeal, and if so, the grounds of appeal, the outcome of the appeal, any action taken to resolve the grievance, and any subsequent issues. A copy of any minutes taken by the company at any formal meeting will usually be given to the colleague. However, the company may withhold the information if, for example, it is to protect the identity of a witness. These records will be considered confidential, although the company will have every right to use all papers arising from the grievance for the purpose of any disciplinary process or legal proceedings. Accordingly, you should note that the company will store and process personal data concerning the grievance for such period as it considered to be reasonably necessary. Another consideration is preparing for the meeting. As a manager, you should arrange a meeting, ideally within 2 working days, in private where there will not be any interruptions. You should consider arranging for someone who is not involved in the case to take a note of the meeting and to act as a witness to what was said. You should also consider whether similar grievances have been raised before, how have they been resolved, and any follow-up action that has been necessary. This allows consistency of treatment. You should consider arranging for an interpreter where the employee has difficulty speaking English, and consider whether any reasonable adjustments are necessary for a person who is disabled and/or their companion. The company will offer reasonable assistance to employees who are disabled or whose first language is not English, to enable them to set out their grievance or their grounds of appeal in writing, and to participate fully in any grievance or appeal meetings. The main points to conduct the meeting are to remember that a grievance hearing is not the same as a disciplinary hearing, and is on occasion when discussion and dialogue may lead to an amicable solution. You should make introductions as necessary. You should invite the employee to restate their grievance and how they would like to see it resolved. You should put care and thought into resolving grievances. They are not normally issues calling for snap decisions, and the employee may have been holding the grievance for a long time. You should make allowances for any reasonable letting off of steam if the employee is under stress. You should consider adjourning the meeting if it's necessary to investigate any new facts which arise. You should sum up the main points, and you should tell the employee when they might reasonably expect a response if one cannot be made at the time, bearing in mind the time limits set out in the organisation's procedure. You should be calm, fair, and follow the procedure. In some organisations, grievances can sometimes be taken as personal criticism. Employers should be careful to hear any grievance in a calm and objective manner, being as fair to the colleague as possible in the resolution of the problem. Each step taken by the company or the colleague in relation to this grievance procedure must be taken without unreasonable delay. Where it is not reasonably practicable within the given period for the company to comply with the need to hold any meetings, the company may proceed to make a decision on the evidence available to it in the colleague's absence and without holding such a meeting. This would be the case where, for example, if the colleague was persistently unable or unwilling to attend a grievance meeting without good cause. For more information on how to deal with grievances, you can contact the HR department. Thanks for watching this session.